Hello friends, welcome to UGC EPG Pathshala. I am Dr. Rangeen Pallav Tripathi. I am a faculty of law at National Law University, Odisha. Today, we will be discussing about the module titled Culpable Homicide Not Amounting to Murder. The primary objectives of this particular module are the following: to understand the meaning of culpable homicide not amounting to murder, to understand the scope of the different exceptions enumerated in section 300. Causing the death of another person is the most severe form of crime against human body contemplated in the Indian Penal Code. Consequently, this crime is accompanied with the maximum punishment of death in case of culpable homicide amounting to murder and life imprisonment in case of culpable homicide not amounting to murder. Generally, a trial of culpable homicide is time consuming and involves greater complication regarding the nature of the offence and the consequences of conviction. Thus, it is extremely important to understand the statutory scheme which deals with the offence of culpable homicide. Section 299 of the Indian Penal Code defines culpable homicide. Section 300 provides a list of conditions in which culpable homicide will be considered as murder. Section 300 also provides a list of exceptions to the conditions which transform culpable homicide to murder. Thus, whenever any culpable homicide comes under the scope of the conditions set out in section 300, the same is considered as murder. On the other hand, whenever any culpable homicide does not come under the conditions set out in section 300 or comes under the exceptions to the conditions set out in section 300, the same is considered as culpable homicide not amounting to murder. Let us now discuss the definition of culpable homicide as provided in section 299. Section 299 of the Indian Penal Code defines culpable homicide in the following manner: X causes the death of Y by committing an act. X commits the act either with the intention of causing death or with the intention of causing such bodily injury as is likely to cause death, or with the knowledge that he is likely to cause death by such an act. It needs to be noted that when X causes bodily injury to Y, which is likely to cause Y's death, it is not necessary for X to have known that the bodily injury being inflicted by him was likely to cause death. It is sufficient if it can be established that X intended to cause the bodily injury which he eventually did inflict. Let us consider an example. X, looking to beat up Y, smashes an iron rod on his chest. Broken ribs of Y pierce his heart and he dies. Here, what needs to be established is that X intended to smash the iron rod in Y's chest, and that in reality such bodily injury is likely to cause death. X's knowledge that such bodily injury is likely to cause death need not be established. The three explanations to section 299 provide further clarity in this regard. Explanation 1. When Y is laboring under any disorder, disease or bodily infirmity, and X causes such bodily injury to Y which accelerates Y's death, X is deemed to have caused Y's death. Explanation 2. When X causes bodily injury to Y resulting in the death of Y, X is deemed to have caused the death of Y even if Y could have survived by resorting to proper remedies and skillful treatment. Thus, X cannot rely on lack of proper medical treatment to escape criminal liability. While having an argument, X hits Y's head with a wooden plank. Friends of Y try to get him to a hospital, but they are delayed due to a strike called by a political party. The doctors are unable to save Y and confirm that chances of his survival would have been better had he been brought in earlier. Here, X is liable for culpable homicide and he cannot argue that the reason for Y's death was the delayed arrival in the hospital. Now, let us look at explanation 3. When X causes the death of Y, who is a child in the womb of his mother, it is not homicide, but causing the death of a living child may amount to culpable homicide if any part of that child had been brought forth, although the child may not have breathed or been completely born. Now, let us look at the different exceptions in section 300 which provide when a particular act by a person will not be culpable homicide amounting to murder. Let us start with exception 1. X was deprived of the power of self-control. X was so deprived due to sudden and grave provocation by Y. X causes the death of Y, or X causes the death of any other person by mistake or accident. X did not seek the provocation or did not himself provoke Y as an excuse for killing him or harming him. X was not provoked by something which Y did in obedience to the law, and X was not provoked by Y being a public servant acting in the lawful exercise of his powers. X was not provoked by anything which Y did in Y's lawful exercise of the right of private defense. If all the above ingredients are fulfilled, even if X might have caused the death of Y, it will not amount to culpable homicide amounting to murder, but will qualify as culpable homicide not amounting to murder. Whether provocation is sufficiently sudden and grave to keep culpable homicide from being considered as murder is a question of fact in each case to be decided according to the varying and particular circumstances. For an act to fall under this particular exception of grave and sudden provocation, the provocation caused to X must be both grave and sudden. Provocation which is not grave in nature or which is not sudden in nature will not be considered under this exception. Thus, when X is provoked by his wife defiantly proceeding to another man's house for committing adultery, and when X is provoked by catching his wife in actual act of adultery, are considered separately in this particular exception. In the first case, though the conduct of the wife constitutes provocation, it cannot be generally classified as grave and sudden. Whereas, in the second case, discovering one's wife indulging in an adulterous act has been held as both grave and sudden provocation. Though whether the provocation is grave and sudden has to be assessed in each case, the court will generally consider how a reasonable man belonging to the same class of the society would react if placed in a similar situation to that of the accused. It is equally important that the grave and sudden provocation must have resulted in a loss of self-control for the accused. If the conduct of the accused shows that even when provoked, he had not lost self-control and was acting deliberately, then any death caused by him will constitute as murder and will not qualify as culpable homicide not amounting to murder. Let us consider an example. X catches Y having sexual intercourse with his wife. He immediately leaves the house and checks into a hotel for the night. Next day, he comes back to his house, talks to his wife. After a conversation, while having a meal, X mixes poison in his wife's food. This is a situation where it is apparent that X has acted with meticulous planning, though it can be said that catching his wife red-handed in an adulterous act must have provoked him greatly. His actions indicate that he has acted with planning and not under loss of self-control. This case will not come under the exception of grave and sudden provocation. Now, let us look at the different ingredients of exception 2 in section 300. X causes the death of Y. X, in good faith, was exercising his right of private defense of person or property. X exceeds the power given to him by law while exercising his right of private defense. X has acted without premeditation. X has acted without any intention of doing more harm than necessary in exercise of his right of private defense. For this exception to be applicable, it is essential that X indeed had a lawful right of private defense in the given situation. Let us consider an example. Y is running towards X with a sword in his hands to attack X. X grabs a brick and throws it at Y in order to prevent him. Unfortunately, the brick hits Y in his head, as a result of which Y dies. This is a situation which will be covered under exception 2 of section 300. Here, while trying to defend himself, X has exceeded his right of private defense. However, X has not intentionally tried to strike the head of Y, but has thrown the brick in the general direction of Y. Now, let us consider another example. X catches Y, a thief, trying to break into X's house. On being caught, Y tries to run away. X shoots at him while Y is trying to run away, and the bullet pierces Y's heart, and Y dies. Here, in this situation, X will be guilty of murder and not culpable homicide not amounting to murder. The minute Y was trying to run away, there was no reason and there was no persisting danger to the life of X or to his property, and thus he had no longer the right of private defense. Now, let us look at the different ingredients of exception 3 to section 300. X is a public servant or is aiding a public servant acting for the advancement of public justice. X causes the death of Y while doing an act which he in good faith believes to be lawful and necessary for the due discharge of his duties. X exceeds the power given to him by law, as X acts without any ill will towards Y. This exception is not applicable when X is trying to do something illegal or something definitely and explicitly beyond his lawful authority. Let us consider an example. X, a police officer, has been tasked with arresting Y, a well-known thug. However, Y tries to resist his arrest by becoming physically violent. In order to overpower Y, X hits him very hard and Y falls down. While falling down, Y's head hits a stone and he dies due to the head injury. Here, X will be entitled to the benefit of this exception as the death of Y has occurred while X was trying to discharge his lawful duties. Let us consider another example. X, a police officer, suspects Y of having an affair with his wife. When there is a theft in the locality, without any proper investigation or evidence, X accuses Y of being the thief and tries to arrest him. Y tries to resist and a fight breaks out. X points his gun at Y and asks him to stop, but Y does not listen. X fires at Y and as a result Y dies. In this case, X will not be entitled to the benefit of this exception and he will be held guilty of murder. Firstly, X was trying to do something which was clearly illegal. Secondly, it is clear that he was not in genuine belief that Y is responsible for the theft, but was trying to settle a personal score. Now, let us look at exception 4 in section 300, and here are the ingredients of exception 4 of section 300. X causes the death of Y. The death was caused in a sudden fight between X and Y. The sudden fight was the result of a heat of passion upon a sudden quarrel. X acts without premeditation. X has not taken undue advantage or acted in a cruel or unusual manner. It does not matter whether X provoked Y or Y provoked X and which one of them commits the first assault. For this exception to be applicable, a mere verbal argument is not sufficient. There must have been a physical fight between X and Y. The fight must not have been a planned one, but a fight which happened in the spur of the moment. In such a scenario, when X has acted without premeditation and has not taken undue advantage or has not acted in a cruel or unusual manner, he will be held liable for culpable homicide not amounting to murder. It is to be noted that both the quarrel and the fight must be sudden. If the quarrel was premeditated but the fight was sudden, this exception will not apply. Let us look at an example. X passes sexual comments on the sister of Y while Y and his sister are walking down the road. Y immediately objects to this and a heated argument ensues between him and X. With neither of them relenting, the argument escalates into a fight. From the injuries suffered in the fight, X dies in the hospital. In this case, Y will be liable for culpable homicide not amounting to murder. Now let us look at another example. X passes sexual comments on the sister of Y. Y's sister complains about this at home in the night. Next day, Y confronts X and a fight starts soon after between X and Y. X dies because of the injuries sustained in that fight. Here, Y will not be entitled to the benefit of this exception, as the cause of the quarrel was not sudden. The quarrel was premeditated on the part of Y, even though the fight between X and Y might have been sudden. Let us look at another example. X being disturbed with loud party noises from the house of his neighbor Y till late at night, confronts Y and asks him to stop the noise. In the fight which ensues, X knocks Y unconscious, and while Y is lying motionless on the ground, smashes a big rock on Y's skull repeatedly. Here, though both the quarrel and the fight were sudden, X acted in a cruel manner. Had Y been killed during the course of the fight by an unintended use of extra force, perhaps it would have been culpable homicide not amounting to murder. However, here X had no reason or excuse to smash a rock on Y's skull when Y had already lost the fight and was unconscious. Now, let us look at exception 5 of section 300. The following are the ingredients of exception 5 of section 300. X causes the death of Y. Y is above the age of 18 years. Y suffers death or takes the risk of death with his own consent. This exception applies to situations where a person has consented to his own death being caused by another person. At one level, it is but the suicidal instincts of a person being executed not by himself but by another person. Let us look at the example. X and Y lost their only son in a road accident. Since then, Y has been severely depressed and keeps on asking X to terminate Y's life as she cannot bear to live anymore. After failing to counsel her, one day X fulfills Y's desire by administering poison to her. In this case, X is liable for culpable homicide not amounting to murder. It needs to be noted that the meaning of consent under this exception will be guided by the guidelines under section 90 of the Indian Penal Code. Thus, consent under this section has to be free. As per section 90 of the Indian Penal Code, a consent is not free under the following circumstances: when consent is given under misconception of fact, and if the person committing the act knows or has reason to believe that the consent has been given due to such misconception. When consent is given under fear of injury, if the person committing the act knows or has reason to believe that the consent has been given due to such fear. When consent is given by a person who, due to the unsoundness of his mind, is not able to understand the nature and consequence of the act for which he is giving consent. When the consent is given by a person who is under 12 years of age. Let us look at an example to understand this particular exception in a better manner. Y is a person of unsound mind and pleads X to kill him so that he can swim in the sky with angels. X kills Y. X will be liable for murder as Y is not a person capable of understanding the consequences of what he is requesting for. Let us look at another example. X assures Y that if Y gives up his life, Y's heart will be transplanted to Y's son, who is suffering from severe coronary problems. Thus, Y allows X to medically terminate his life. However, X never intended to use Y's heart for Y's son. He instead uses it for Z, the son of a powerful politician. Here, the consent of Y is given under the misconception of fact that his heart will be used for his own son. That is why, in this scenario, X will be liable for culpable homicide amounting to murder. To conclude, in order to summarize this particular module, the following things should be kept in mind. Any culpable homicide which falls under the exceptions to section 300 or which do not fall under the exceptions but is also not covered under the conditions of murder enumerated in section 300 is classified as culpable homicide amounting to murder. Grave and sudden provocation which does not result in a loss of self-control does not fall under the purview of exception 1 to section 300. To claim the exception of grave and sudden provocation, the accused must not have sought the provocation himself. For exception 2 of section 300 to be applicable, the right of private defense must be subsisting when the accused causes the death of the victim. For exception 3 of section 300 to be applicable, the public servant or the person aiding the public servant must not be doing something illegal or something which is definitively beyond the lawful authority of the public servant. For exception 3 of section 300 to be applicable, the public servant or the person aiding the public servant must not have had an ill will towards the victim. For exception 4 of section 300 to be applicable, both the quarrel and the fight must have been sudden and not premeditated. For exception 5 of section 300 to be applicable, the consent of the person whose death has been caused must have been a free consent under the meaning of section 90 of the Indian Penal Code. That would be all. Thank you.